Hello, everyone. This is Adrian with PrepAgent. Welcome to today's webinar on practice and disclosures. If you can hear me, let me know. Throw a thumbs up in the chat or say sounds good, sounds aight. Sweet. Looks like everybody can hear me. Good morning or good afternoon, depending on where you are. Hope everybody's been staying safe and staying sane. It's a little hard to do these days, but we got to be like halfway through this thing, right? That is my hope, at least. Right. Looks like everybody can hear me. Everybody's ready to get some study on, some practice. I don't know if we have any Allen Iverson fans out there. Practice? Talking about practice? We are talking about practice and disclosures today. Well, we got one or two buffers, so I'm just going to type a quick note. So lots of people doing some buffering. Sorry if you get any long pauses. I'm just double checking my connection. And now I am back. Everybody's refreshing. It looks like we are good to go again. If you don't hear anything, check the volume icon on the YouTube window. And that looks like we've got everybody back online. So sorry for the buffer to begin. It's just one of the things that we're dealing with now with everybody being at home and online. But it looks like now we are ready to rock and roll. So we're going to be talking practice and disclosures. There's a lot to cover with practice and disclosures, even though it's mostly all related to just a few different things. But we're just going to dive into the questions and then we'll dig a little deeper as we go. Hello, Anahan. Hope you're doing well. Beverly asks, is it too late to submit math questions? It's never too late to submit the questions, Beverly. They're not going to make it into tomorrow's webinar. It's probably a little bit late for that. And I think Joe is all locked down on the questions that he's going to do tomorrow. But any math questions that you all submit will go into the bank for future webinars. So go ahead and send those in, and then I'll send them to Joe, and we'll get them on the docket for an upcoming webinar. Hello, Justine. Welcome. And let's go ahead and get rolling. Start with the question on the board. Good morning, Supriya, and welcome. Oh, real quick, before we jump into the questions on the board, Alzira threw up his 5 words of the day. So for those of you who might be new, Joe recommends, and I agree with this, that you pick at least 5 words, somewhere between 5 and 10 words every day, and study those 5 words. Alzira chose estate at sufferance, accretion, avulsion, reliction, and lease. So lots of property ownership type of situations. If anybody else has 5 words they want to share, it's good to see those get thrown up in the chat because it can inspire others to choose maybe one of those words. If somebody throws up a word that you haven't seen before, it's good to throw that word into your own study bank, right? Something to look up. So, for example, Lynn Kirkman chose fair housing, RESPA, TILA, ADA, and steering. Those are all things we're going to be talking about today with practice and disclosures. So that's an excellent thing to do. If you're planning on attending the webinar, choose 5 words that are relevant to that day's topic, and you'll get better at 2 things at the same time. You'll get better at your vocabulary overall, Plus, you'll get better in a specific category. Dante did escalation clause, construction loan, takeout loan, warehousing subordination. Nice work. Let's go ahead and start this then. So, in one of her weekly sales meetings, broker Elizabeth Johnson made the following two statements to her sales staff. We're going to solicit listings in the Rancho Los Cabos neighborhood because of a large number of Black and Asian buyers moving in. Number two, we'll only advertise the listings in that neighborhood to Black and Asian buyers. Which, if either of these statements is correct? A, number one is legal, but number two is illegal. B, number one is illegal, but number two is legal. C, both number one and number two are illegal. And D, both number one and number two are legal if part of the conversation is kept within the firm and if they are not discussed publicly. So what does everybody think here? Also, I did notice that some people were asking about tests earlier. We've seen that the DRE in California has test centers to start coming online starting in May. If you're in a PSI state, your testing centers will start coming online potentially in mid-April. So I've posted a link in the chat to their schedule of those. So if you scroll down to the bottom of the link and choose the USA, you'll see all of their estimated reopening dates for PSI states. Back to the question on the board. In one of her weekly sales meetings, broker Elizabeth Johnson made the following two statements. One, we're going to solicit listings in the Rancho Los Cabos neighborhood because a large number of Black and Asian buyers are moving in. And number two, we'll only advertise the listings in that neighborhood to Black and Asian buyers. And the correct answer here is C. Both number one and number two are illegal. And this is a fair housing thing. Both of these are in violation of fair housing laws. And kind of the clue is that you can look at it and say, okay, well, the first statement has Black and Asian buyers. The second statement has Black and Asian buyers. So they're targeting color and race. Anytime you're doing that and making decisions based on color and race, you are in violation of fair housing. So Brooks Portasio says steering. That is exactly what's going on, pretty much, because there is a neighborhood with some minorities in it. And so if you're only pointing minorities to that neighborhood and that's the only neighborhood you're showing them, you are steering. Let's jump to the next question on the board. Stephen Douglas has been burning leaves on his front lawn. His neighbors have filed a lawsuit and have received a court order ordering Mr. Douglas to stop burning the leaves. That court order would be called A, a variance, B, an injunction, C, a lease pendens, or D, a writ of habeas corpus. We're going to test your law knowledge. And while we're doing that, I'm going to get a link. A couple people asked about testing site reopens in California. So I'm going to post that link right now. That is courtesy of Arthur, who dug that link up for us. So all you California types, big welcome to Arthur for finding important, helpful information. But basically, to my understanding, DRE is starting to, depending on your testing location, they're starting to reschedule stuff as we speak. So back to the question on the board. Stephen Douglas has been burning leaves on his front lawn. His neighbors have filed a lawsuit and have received a court order ordering Mr. Douglas to stop burning the leaves. That court order would be called an injunction. The answer is B, an injunction. So an injunction is simply a court order to stop or prevent certain actions by certain individuals or entities. So for example, if you live in a housing subdivision and one of your neighbors is burning leaves, you can file an injunction to have them stop. So obviously, in order for that to go through, it's got to be something that's like a public nuisance or is actually illegal, for you to report and for the court to say, yep, like we agree that's something that Stephen Douglas should not be doing. So in that case, his neighbors file an injunction. Stephen Douglas is ordered by a court to stop and can actually have a warrant issued if he violates that. Richard asks, a lease pendens is a lawsuit pending. That is correct. A lease pendens is a pending lawsuit, and that comes up in situations where you're trying to convey a property, but perhaps there is a mechanics lien or something else on it that needs to get resolved before the property should be solved or sold, excuse me. In that case, the person with the lien or the person who is seeking monetary satisfaction would file a lease pendants to prevent a property from being sold. Makes sense? That's not super practice and disclosure-y, so I'm not going to go any deeper into that. But if you have questions, you're always welcome to send them into us on the website using the contact form. Next up, a written purchase agreement has been signed by both a buyer and a seller. The Uniform Vendor and Purchaser Risk Act states that until the buyer has either possession of or title to a property, responsibility for the physical condition of the property, A, is delegated to the buyer, who upon signing has equitable title to the property. B, is assumed by the seller's homeowner's insurance company. C, remains with the seller, or D, is given to a third party. So what does everybody know about the Uniform Vendor and Purchaser Risk Act? Not even something that you would think would relate to real estate necessarily, but it absolutely does. So when you have a situation in which a written purchase agreement has been signed by both a buyer and a seller, the Uniform Vendor and Purchaser Risk Act states that until the buyer has either possession or title to the property, responsibility for the physical condition of the property, C, remains with the seller. Lisa asks, we did not have the Uniform Vendor and Purchaser Risk Act in your class. That's because, Lisa, a lot of states don't require you to know about this, but it is something that can come up on any PSI exam or on the DRE exam or on the New York exam. But it's not something that comes up often, which is why it's not required to be in your pre-license course material. And the Uniform Vendor and Purchaser Risk Act doesn't apply specifically to real estate, which is why you may not have heard of it. It applies to a lot of vendor and purchasers. Basically, all it's saying is that until you hand over possession of something that you are selling, you are responsible for keeping it in good condition. That's all we're talking about there. Somebody else, Latice says, you won't receive your title until it's paid. That's correct. So if you take a mortgage, Latice, what would actually affect that Uniform Vendor and Purchaser Risk Act is when you take possession of the property. So, the lender, you're not going to take physical possession of the title until you've actually paid that final payment, which means you could live in a home for 30 years before you get the title. But taking possession, once the buyer takes possession, that absolves the seller of that responsibility for the property, for taking care of it, for its physical condition. Make sense? We will move on. Thanks to everybody for sharing what you know about the testing centers in your area. It's really hard to dig up all that information. We're doing our best to keep you all apprised of the situation as everything involves. But it's a lot of stuff to track, so we appreciate any help you all give us with that, and you all give each other too. It's awesome. Mrs. Lee received a loan application from her lender asking her to specify her marital status and ethnic background. Legally, she can A, sue the lender and the real estate broker for discrimination, B, refuse to fill out that portion of the loan application, C, not decline to answer those questions if she wants the loan, excuse me, or D, be denied the loan if she refuses to answer those questions. What does everybody think about that? It's all right, just had to take a little coffee sip. Hope you didn't have to hear me swallow there. We have a coffee shop in the neighborhood that's open that has amazing apple fritters. Apple fritters were something I didn't know could be amazing till I discovered the ones at this particular coffee shop. So it's kind of my pre-webinar routine is to go grab a coffee, go for a little walk, grab a coffee, get an apple fritter, and enjoy life just a little bit. All right. So Mrs. Lee received a loan application from her lender asking her to specify her marital status and ethnic background. Legally, she can B, refuse to fill out that portion of the loan application. So a couple of people asked if she can sue for that, and she cannot sue for being asked those questions. However, if she refuses to fill that out and she is denied the loan because of that, she can sue. At that point, it becomes discrimination. Asking the questions, putting those on the loan form, not quite discrimination yet, but it's really close to it. Once they choose not to lend to Mrs. Lee based on her decision to not fill out that portion of the loan application or based on her answers, at that point it becomes discrimination and suable. So apologies for those who did hear me swallow, and good on you for those who have the apple fritter appreciation. Joe has always known that those are the best. They are incredible when you get the little pieces of apple inside instead of just a little bit of apple spice. All right, let's move on to the next question. Alzira says, asking not discrimination, no lawsuit, but if denied the loan, then it is discrimination, you can sue. Exactly. You got the gist of it there. Asking is not yet discrimination, but making a decision based on the lack of response or the response would make it discrimination. Danae asks, does Miss means that she is not married? Yes, if it's not a Mrs., if it's just MS, it does mean that she is not married. Next question on the board. Two brokers decide to list a property together and agree to split the commission 50-50. One broker finds the buyer and then refuses to share the commission. To recover the agreed upon portion of the commission, the deceived broker could file an action, A, with the Department of Real Estate only, B, with the civil court first, then in a criminal court for fraud. Excuse me, that was B. C, in a civil court only, or D, with the Department of Real Estate first, then in a civil court. Kathy asks, not in writing. I'll talk about that in a minute, Kathy, but it's not pertinent here. Yay, I pronounced Danae's name correctly. I had a friend in high school who had something similar, so that may have helped. But I'm always happy when I get somebody's name correct. So, in this situation where two brokers decide to list a property together and agree to split the commission, one broker finds the buyer and then refuses to share the commission. To recover the agreed upon portion of the commission, well, first, let's break this down a little bit. So the agreement that we're talking about is an agreement that has to do with real property, or is it an agreement between two individuals that has nothing to do with the property itself? So to understand the correct answer, the first thing we need to understand is what this question is asking us about. So let me know what you all think. Are we talking about an agreement that has to do with real property or about an agreement between two individuals that has nothing to do with real property? because our answer is going to be different. So this particular question is asking about an agreement between two individuals, right? It's just the agreement between the two brokers. Once the seller pays the commission to the broker, this is no longer a real property situation, right? So the statute of frauds applies for the seller paying that commission to the broker that finds the buyer. After that point, it becomes a civil situation between the two brokers, right? So the answer first is C, in a civil court. The two brokers need to decide this in a civil court. The Department of Real Estate is not involved because we are not talking about a real property situation. There's no license law being tested here, and there's no problem with the transaction between the seller and the broker that found the buyer. So that's what removes the Department of Real Estate from being involved. This is simply a matter between two individuals, regardless of their situation, and so they're going to settle it in a civil court. Makes sense to everybody? It looks like everybody has that. Diana asks, mediation depends on the state. That is true, Diana. That is true. Every state has their differences there, but it is important to note that because it's a civil matter, that's the side that is going to handle this particular dispute. Right. Sarah says, thanks for explaining that. I'll remember that forever now. Awesome, Sarah. I hope that information comes in useful. You're going to show yourself to be the smart cookie in the classroom when that comes up and you're like, actually, this is how that situation breaks down, right? All right, next question. A listing broker had a signed sale contract on a house. The broker then noticed a crumbling wall in the basement. Which of the following should the broker inform about the wall? A, both buyer and seller. B, the buyer, seller, and the mortgage company. C, the buyer only, or D, the seller only. So Zero says in Colorado, they're required to mediate first before being able to take something to a civil court. That totally makes sense for sure. That makes sense. As long as we all understand that it's not likely to be a Department of Real Estate or Real Estate Commission that is mediating anything to do with that situation. And back to this question, a listing broker had a signed sale contract on a house. The broker then noticed a crumbling wall in the basement. Which of the following should the broker inform? And the answer is A, both the buyer and the seller. So the listing broker needs to let the seller know because of, well, you all tell me, what duty does the broker owe the seller that means that broker needs to inform the seller of this material fact? Yes, it matters that it's a material fact, but there is a specific relationship between a broker and a seller that requires the broker to be loyal to the seller, and that is fiduciary. Bang, Patrick, Jessica, Justine, the fiduciary duties, right? So that's why the broker needs to inform the seller. The broker needs to inform the buyer, or the broker needs to have the seller inform the buyer because it's a material fact. Makes sense? So there's sort of two different relationships going on here. And there's the broker's relationship to the client, which has a fiduciary responsibility to report it. And then there is the broker's relationship to the buyer, which requires all material facts known to be disclosed. That makes sense to everybody? All right, quick study break. I want everybody to tell me their favorite thing about this week. It could be something that happened or is going to happen. I'm going to share mine. I'm a big fan of being able to wear shorts, and it's the first week that it's been warm enough for me to do that. So I've been rocking that even when it's still a little chilly outside. I'm rocking the shorts. because I don't know, because it's comfortable and because it means summer and because it means relaxing. So that's been my favorite thing about this week. Ooh, Patrick said the wind stopped in Palm Springs. Love it when the wind dies down. Michelle is planting a garden. That is awesome. Sun is out. Love that. Government relief checks, that's for sure. Stimulus checks have been nice. Jessica has seen the sun in Washington. Ooh, Rita's making key lime pie today. If the local donut shop had key lime pie, I would switch to that in half a second. I love key lime pie. Joe says he wears very retro shorts. I assume that means they're very tight and very short. Not sure if I needed that visual, but you do you. You do you, buddy. Some people having snow. Well, then you still have snow ports, so that's snow sports. That's nice. Somebody got a puppy. Its first haircut looks like a teddy bear. That sounds adorable, Cassie. I love that. Sierra says working out is keeping her sane. I love that too. I have not been working out enough. Need to make that happen. And Sarah says Joe's wearing a Speedo. He might be. There's a reason that we don't want Joe's camera on when he's doing the webinars. And I think it could be because he wears a Speedo. I know he likes to swim, so that makes sense. Melissa, studying a lot this week, getting more discipline. That is awesome. Love to see that. I've been working on that myself in quarantine times, trying to stay more disciplined with all the extra time. All right, now we're talking about Joe doing yoga in Speedos. I think that's the cutoff point where we're about to cross a line. Might cause a few people to pass out. So we are going to get back to the questions on the board. But thank you all for sharing. Lots of awesome stuff happening this week and lots of awesome perspectives about the stuff that happened this week. One of the unplanned benefits of this whole quarantine thing is a lot of us seem to be developing an appreciation for the little things that we used to take for granted. Ooh, Christine walked 6 miles to a beach yesterday. I'm a big fan of that. Kristen, Speedo Joe, the new name. Love it. Love it. All right, back on track, everybody. When a buyer gives the agent a post-dated check, it A, may be retained but must be disclosed to the seller. B, may not be accepted by the agent. C, must be delivered to the seller within 1 day. Or D, must be cashed immediately. Melissa asks, what's going to happen with the real estate business with the pandemic? We'll hand that off to Joe to talk about in an upcoming webinar. I know he's got some thoughts on what's going on with the industry. Most of what I've seen and what the smart people involved in the industry seem to feel like it will recover. Just like everything with the economy, it may take some time, but it will absolutely recover. The need for property is not going away. And, to be honest, right now, like if I could rethink stuff 10 years ago, I would have probably made sure that I was in a much nicer place for quarantine, something a little bit bigger than an apartment. So who knows? Like people may be even more invested in homes. All right, back to the question on the board. When a buyer gives the agent a post-dated check, A, it may be retained but must be disclosed to the seller. So as with all different types of earnest money deposits, as long as the seller is willing to accept it, as long as there is value to the seller, it's acceptable as an earnest money deposit. It may not be, optimal, but it's acceptable. Relentless says, I thought an agent cannot accept post-dated checks. The broker has to give him or her permission. The agent receives it. It must be sent to the broker immediately. A lot of that, Relentless, Ruthie, is going to be dependent on your state as far as how quickly an agent needs to hand a post-dated check to the broker. And of course, the broker is going to need to run it by the seller before that is completely acceptable. But as long as the agent runs it through the appropriate channels, checks with the appropriate people, then it can be an acceptable form. I'm not aware of any state where that's not true. So if you have other information, please feel free to send that to me using the contact form on our website. I will absolutely take a look at it. But I'm not aware of that, any limitations there. Karen asks, can the seller say no? Yes. The seller can say no to any type of earnest money that doesn't meet their definition of value. Patrick asks, why wouldn't you turn it over to the seller? Because most of the time, Patrick, earnest money needs to be held in an escrow, which is an impartial third party that just sort of hangs on to whatever that earnest money might be until some conditions have been met, at which time the money becomes the seller's. All right, let's move along. In which of the following situations may a real estate licensee lawfully refuse to show a home to an Asian prospect who has requested to see it? A, when the owner is out of town and has instructed the licensee that no showing may be made in his absence. B, the agent may not refuse to show any home to an Asian person at any time. C, when the licensee sincerely believes that showing the property would cause panic in the neighborhood. Or D, when the owner is exempt under the 1968 Fair Housing Law and has stated that his single family home is not available to Asian persons. So Ruthie asks, post-dated checks are basically checks that are received after the required deadline of the sale. Not necessarily, Ruthie. Post-dated checks just mean that I'm giving you this check today. It's dated for April 20th, so technically you're not supposed to be able to cash it before April 20th. But for the most part, post-dated checks are still considered good as cash. One thing that is not acceptable as an earnest money deposit that I forgot to touch on in that last question is a credit card. And the reason for that is that something like a post-dated check is pulling from funds that you own as a buyer, right? That money is yours. The reason that credit cards are not allowed as earnest money for the most part is because that money was never yours. It never belonged to you. It always belonged to the bank that advanced you the credit card. And so that is not acceptable for earnest money. So, Melissa, I believe I just answered your question. I saw that one coming. I was prognosticating. I answered that before you even asked. All right, we're going to close out strong here with a few more questions. We're going to run through these as fast as we can. A couple more concepts I want to touch on today. In which of the following situations may a real estate licensee lawfully refuse to show a home to an Asian prospect who has requested to see it? And the answer is A, when the owner is out of town and has instructed the licensee that no showing may be made in his absence. So this is sort of a trick question that comes up a fair amount with PSI exams. That's why we got it in our practice exams. But the important part of this answer is that the owner has instructed the licensee that no showing may be made while he's out of town, period. No showing. So it doesn't matter if the prospect is Asian or Hispanic or Scottish or Australian. Doesn't matter where they're from, no showing can be made. So it's not discriminatory. They're not showing it to anybody. Any of these other situations, it's discrimination and it's not allowed. And this one comes up too. If a contract for sale provides that the owner is selling his home in an as-is condition, then A, hidden and latent defects must still be disclosed to the purchaser. B, the owner is generally immune from liability. C, caveat emptor applies. Or D, the broker must assist the buyer in making a thorough inspection. What do you think here? Melissa asks, Just remember seeing a lot of questions about ads. So we don't talk about ads in any of our videos, and we don't cover them too much in the webinars because they're very state specific. Advertising in regards to real estate is regulated by your real estate commissioner or Department of Real Estate on a state-by-state basis. Every state has different laws regarding that, so we don't cover it in videos because we only do national content in the videos and webinars. We want this information to apply to everybody. So anything that we have about ads will be in your state-specific practice exam if you've got one. Back to the question on the board. If a contract for sale provides that the owner is selling his home in an as-is condition, then A, hidden and latent defects must still be disclosed to the purchaser. I saw a few people mention or ask what latent defects were, and somebody else threw up a definition that says not obviously found, and that's obvious is sort of the key word there with regards to latent defects, similar to hidden. And in this situation, the seller's requirement for disclosure still exists. So any known material facts must still be disclosed. Caveat emptor stands for buyer beware, which basically means buy at your own risk, right? We're not going to give you any information at all. We're just handing this over. So anytime you have a contract for sale, however, there is a seller disclosure requirement regarding known material facts. So let's ask, when does caveat emptor apply? It's going a little bit off topic. It's going to be the last question for the day, but when does caveat emptor apply? There is one situation that we talk about in regards to property transfer when caveat emptor applies. Joel DeGuay, nice job, hit it right on the head with a quitclaim deed. With a quitclaim deed, caveat emptor applies. That means there are no warranties, there is no seller disclosure. Usually with the quitclaim deed, there is no contract for sale. There is just a change of ownership in the property. And so because there's generally no sale, because it's just a change of ownership, you can have a buyer beware situation. But anytime a buyer is purchasing a property, they are generally protected by disclosure laws in your state, and they're required to disclose any known defects in the property. Does that make sense? Anything that's not known ahead of time and that the buyer finds out after is not on the seller. You know, they only have to disclose the known material facts. Does that make sense to everybody? So caveat emptor applies to quitclaim deeds. It does not apply to a home being sold as is. And that is going to do it for today, everybody. So thank you all so much for dropping in and spending this time with us. Gives, as Joe has mentioned many times before, it gives us something to look forward to. Love seeing 200 people studying on a Thursday morning / afternoon. That is awesome. I hope you all have a great rest of your day. Tomorrow is a big day for us. Joe's going to be on the mic doing a math webinar. Thank you to everybody who submitted questions. A lot of those will be in the webinar for tomorrow. The rest of those will go in later. I just saw something about Joe and naked yoga scrolling up through the chat. And I don't think there's a better way to end than on that thought. So thanks again, everybody. Stay safe, be well, be kind to each other, and we will see you tomorrow.